Good morning. I'm delighted to welcome you all to our webinar this morning. For those of you who don't know me, my name is Dorit McCann. I'm a partner here in Mason Hayes & Curran, and I head up the public procurement team. We will have two presentations today. The first one will be from Aoife Beirne. Aoife has been a barrister since 2012, and she specializes in public procurement law. And she has appeared in many of the recent cases for applicants, contracting authorities, and notice parties. And most recently, she's acted for the successful applicant in the White Mountain case, which related to abnormally low tenders. And she acted for the notice party in the respondent's application to lift the automatic suspension in CHC and Minister for Transport. That was the Search and Rescue Services case for the Irish Coast Guard. She's also former coordinator of the Advanced Diploma in Public Procurement Law run by King's Inns, and she remains a lecturer on that course. We are delighted to have Aoife join us today for our webinar and taking the time out of a very busy schedule to give us a presentation on the most recent Irish case law. After that, we will hear from Niall Michel, who's a litigation partner in our Public Regulatory and Investigations team. And Niall has extensive experience, of advising on judicial review, public procurement, and access to the environment, access to information matters, which includes access to the Environment Information Regulations. Niall is going to talk to us today about the use of freedom of information in the context of procurement disputes. Following the two presentations, we will have an opportunity for Q&A at the end. So please feel free to ask any questions in the Q&A box throughout the presentations, and we'll pick up as many of them as we can at the end of the two presentations. But before I turn over to the presentations, I just wanted to mention a number of recent EU cases in the last number of months. The first one is the case of Pharmacia, where the European Court ruled that operating a pharmacy is an economic activity and therefore subject to the Concessions Directive. And the court clarified that national regulations for pharmacies do not alter the economic nature of the activity, but that pharmacy concessions can benefit from the simplified procedures under the light touch regime. So a very interesting case for those procuring pharmacy concessions. In the case of Aoife, I hope I'm pronouncing that right, that refers to the legality of an award criterion which assessed an increase in the rates of pay over the rates of pay in collective agreements. So potentially very relevant in the Irish context. We currently only have the Advocate General opinion, and that stated that contracting authorities are permitted to include an award criterion such as this, which relates to social aspects of pay. And he then also considered a related question, which was whether this award criterion was linked to the subject matter of the contract. And ultimately, the Advocate General considered that it was, because there'd previously been lengthy protests by employees, and therefore the authority said that it needed to ensure that a continuous and an adequate service is maintained throughout the contract term. So a very interesting judgment as well. And then finally in Dhaka, the European Court ruled that the purchase of green electricity certificates constitutes an activity for the purpose of supplying electricity to fixed networks. And therefore, that activity fell within the Utilities Directive. But now I'll be turning you over to Aoife, who will be covering the most recent Irish cases that have been in front of the Irish courts.
Thank you, Dorit, and thank you to Mason Hayes & Curran for the invitation to speak today. So I've been asked to speak about recent developments in public procurement law, and I'm confining my discussion to recent Irish cases. There haven't been that many reported Irish decisions in the past year or so, but as everyone here knows there's always a challenge or two brewing somewhere, even if they don't make it to court or to a reported decision. So what I'm going to talk about three main areas. So I'm going to talk about the successful application to lift the suspension in the Skellig Vickle case. Then I'm going to go on to discuss a case concerning an application for discovery of a tender's confidential tender submission, and it also deals with confidentiality rings. That's the decision in Kerrigan, Shannon, Newman and the SEAI. And then finally, I'm going to just touch on the recent Court of Appeal decision upholding the High Court decision in Killary Lighting Services and Mayo County Council, even though there was a difference of opinion in some areas between the High Court and the Court of Appeal in that case. So just moving on to the next slide, please. Thank you. And the first case I want to discuss is Atlantic Endeavour and Office of Public Works. So this was an application to lift the automatic suspension, and it concerned a competition run by the OPW for the allocation of land permits on Skellig Vickle. And the permits had been scheduled to commence on the 8th of May 2025. And the decision by the OPW was challenged by two tenders, and obviously this gave rise to an automatic suspension. And the OPW brought an application to lift the suspension under Regulation 9. So the permits had been scheduled to commence on the 8th of May 2025. By the time the applications to lift the suspension, which were heard together, were heard, that happened in June 2025. So it was accepted at that point that part of the landing season, which I think runs from May to September, so it's quite short, had been lost. So that was accepted in that case. Just the next slide, please. So Judge Simons was the judge in that case, and he summarised the relevant principles which are applicable to applications to lift the automatic suspension. And these have been set out now in a number of cases, like the word perfect decision and the decision in CHC. So essentially what the court does, and there's a helpful summary from Judge Simons here, what the court does is it proceeds on the hypothetical basis that an interlocutory injunction has been applied for. So if the court decides that an injunction would have been granted, then the suspension should remain in place. And these are the Campus Oil, now Merck principles. So they concern whether, the first question to be asked is whether there's a fair question to be tried. And secondly, whether the balance of convenience favours the grant of the injunction. And the question of the adequacy of damages is considered now as part of the balance of convenience limb of the test. And Judge Simons summarised that damages in principle are available if the appropriate concession is made that damages are sufficiently serious under the Frankovich criteria. However, he said that just because damages are available doesn't necessarily mean that they are adequate. He acknowledged the complexities in assessing damages in public procurement cases on the basis of loss of chance. And he says that the more tenders that are involved, then the more uncertain that question might be, and that uncertainty may give rise to a conclusion that damages are not an adequate remedy. He also said that it was critical to consider the period of time for which the automatic suspension will be in place. So if, for example, an early trial date has been fixed, then the suspension won't be in place that long. Obviously, you have to wait for the judge to actually issue their decision, but that may weigh against the lifting of the suspension. And then finally, the court said that it can take into account the probable consequences of the lifting of the suspension for all interests, including the applicant, the successful tender, and also the public interest. And you'll recall from the CHC decision that the public interest was an important consideration there because it was regarded as being a life-saving contract. So just moving on to the next slide, please. Judge Simons granted the application to lift the suspension in that case. And in weighing up whether or not to lift the suspension, he said that the factors against lifting the suspension were that the conclusion of the contract would relegate the applicant's claim to a claim for damages, and that an early trial date would negate any disruptive effect. So, on the other hand, he said that the factors in favour of lifting the suspension were that damages were an adequate remedy in respect of the 2025 landing season, the adverse impact on successful tenders and the local economy would be disproportionate to the benefit to the unsuccessful tenders, and that there was a public interest in the orderly implementation of prima facie lawful decisions of public authorities. Now, and just moving on to the next slide, please. One aspect of the balance of justice here was the status of the contractual rights to be conferred on the successful tenders. So the tenders had been required to commit to the execution of a pro forma contract, which was appended to the RFT for the 2025 season. However, in other sections of the RFT, it stated that they intended to enter into a 5-year framework. So there was a dispute there as to if the suspension were to be lifted, what form the actual contract would take. And Judge Simon said that usually it wasn't for the court to, in an interlocutory application like this one, to make findings relating to matters of factual controversy. But he said that it was not possible to avoid making such a finding about the duration of contract in his assessment of the balance of convenience. So he held, on the basis of the tender documentation, that the legal effect of the lifting suspension allowed the grant of the landing permit just for the 2025 season. However, he did stress that this decision didn't involve a finding on whether the outcome of the process allowed the OPW to award contracts to the 15th, to renew the contracts for a 5-year period. Now, there had been a very early trial date fixed in that matter. The trial had been fixed for July 2025, and this motion was heard in June 2025, but those proceedings ultimately resolved. So we won't get to find out whether the OPW would have been able to enter into a 5-year framework or whether they wouldn't. So the next case which I want to discuss is the Kerrigan, Shannon, Newman and the SEAI, and that's just on the next slide, please. So this is an abnormally low tender case, which is currently making its way through the commercial list of the High Court, and I should say I appear for the notice party in this case, and it's listed for hearing in December of this year. But there has been a decision there's been 2 decisions, one of the High Court and one of the Court of Appeal, on the discovery application which was made in that case. So it's an abnormally low tender case primarily, and it concerns a competition run by the SEAI for the provision of managing agent services in connection with retrofitting houses. So carrying out BER surveys, inspections and all of that. And it has an estimated worth of €75 million. And the applicant claims in that case that the notice parties or the successful tenders tender price is abnormally low, and there is another argument that the successful tender is not permitted to combine services under the contract having regard to the provisions of the RFT. So, for example, the argument is made that the RFT doesn't permit having, for example, a survey and an inspection on one day in one visit. Whereas it's not in dispute, and it's in the judgments that is the basis upon which the notice party has tendered. Now, some discovery was agreed in this case, and a confidentiality ring was put in place, but there was a dispute about other categories of discovery. So the main dispute related to Abtran's tender submission, because the applicant sought discovery of Abtran's tender submission as it relates to its pricing and also as it relates to its submission on combining services. Also, even though a confidentiality ring was agreed, it was agreed that it was an expert and lawyer confidentiality ring. However, the applicant claimed that in order to give proper instructions, that a client representative should be allowed access into the confidentiality ring. So an employee of the applicant should be allowed access into the confidentiality ring. And they proposed a particular individual who said that they would give undertakings similar to the lawyers and the expert in that case. And just to bear in mind that in the White Mountain proceedings, there was a client representative in the confidentiality ring in that case. However, that was by way of agreement. And so there was client representative, experts and lawyers. That was by agreement. So there was never any dispute in that case about whether or not an employee of the applicant should be allowed into the ring. But in this particular case, it was a dispute, and a dispute which made its way to the Court of Appeal. So just by way of background, discovery, and just moving on to the next slide, please, thanks. Discovery and confidentiality had been discussed by the former Chief Justice Frank Clark in the Word Perfect decision in the Supreme Court, and that decision confirmed that the normal test of relevance and necessity in discovery was appropriate for public procurement cases, and that no special test needed to be applied. It did acknowledge that there would be obviously separate concerns regarding confidentiality in public procurement cases, but that the court needed to balance the competing interests of the applicant in seeking to prove its case and the undoubted protection that the successful tenderer has regarding their confidential information. So usually in discovery, confidentiality is not a bar to disclosure. That remains the position, but it takes on a heightened relevance, obviously, in public procurement cases. But the court said that it has to be weighed up, and the court did mention that one form of, protection for a successful tender would be using a confidentiality ring, and the Chief Justice mentioned a couple of cases from England concerning confidentiality rings. So just turning to the applicant's claim that they were entitled to the notice party's pricing submission, they accepted, and this is recorded in the judgment, that pricing is obviously one of the most commercially sensitive aspects of the tender. And Judge Toomey, who is the judge in the High Court, stated that confidentiality is an indispensable part of the procurement process. And in order to be afforded access to pricing, it had to be convincingly established that the disclosure of the pricing information was indispensable for the resolution of the dispute. And that comes from the Word Perfect decision. And just moving on to the next slide, here Judge Toomey decided that disclosure of the notice party's pricing submission was not necessary for the resolution of the proceedings. Bearing in mind here that this is an abnormally low tender case, but this isn't like the White Mountain decision. Here, the SEAI had identified that the notice party's tender appeared to be abnormally low, and they had carried out the inquiry, which is mandated by Regulation 69. And they had carried out all of their investigations, and there was back and forth about that. So the dispute between the parties was not whether the tender price was abnormally low, because the SEAI had already decided that it appeared to be abnormally low. The focus in the case was going to be on the legality of the Regulation 69 inquiry that the SEAI took. And the SEAI had already agreed to provide discovery of the evaluation report and the communications between it and the successful tenderer arising out of that inquiry. So Judge Toomey found that for that reason, that the disclosure of the pricing wasn't necessary for the resolution of the proceedings, and he refused discovery of that category. And just moving on to the next slide, in relation to the applicant's application for discovery of the notice party's tender submission relating to combining these services, combining inspections and surveys in the same site visit, is not in dispute in the judgments that that is connected, or it's interconnected with the pricing submission, because obviously if you can combine services, then your prices can be lower. So it's referred to in the Court of Appeal judgment that they are interconnected. But here, Judge Toomey in the High Court at least found that the applicant should not be granted discovery of the tender submission in relation to combination of services for a number of reasons. The first reason was that it wasn't in dispute that the successful tender was premised on combining these services. It had been averred on affidavit by the SAI and by the notice party that this is what it was based on, and therefore it was not necessary for the resolution of the proceedings, Judge Toomey held. And then he also said that whether or not combining services was permitted under the tender documentation was a matter of interpretation of the tender documents, and that was a matter for the court, and that's the Gaswise decision. So there was no need for discovery there. That's what Judge Toomey decided. Now, the Court of Appeal ultimately disagreed with that part of it, but I'll just come to that in a few minutes. But I just want to deal with the next slide, which is Judge Toomey's decision on whether or not a client representative should be permitted in the confidentiality ring. And it was claimed that it was going to be very, very difficult for the applicant to give instructions to their lawyers if it was just the lawyers and the expert in the confidentiality ring. And Judge Toomey noted that the representative had given an undertaking which illustrated just how fundamental the information was. He did note that there was no way that the court could police this undertaking. He made a comment that once information is known, it cannot be unknown. In the CHC decision, sorry, the next extempore decision of Mr. Justice MacDonald in CHC, is actually no written judgment, but in the discovery application, Mr. Justice MacDonald actually even refused an expert access to the confidentiality ring. He said it should be a lawyer's only confidentiality ring. So confidentiality rings are ordinarily only open to lawyers and experts. And in the Word Perfect decision, Judge Clark had mentioned in passing cases about confidentiality rings, and these were dissected in minute detail, and Judge Clark's words and the way he phrased things were dissected in minute detail by the lawyers in both the High Court and the Court of Appeal in this particular case as to what he actually meant and whether or not he had approved certain English decisions which said that it is okay that you have a client representative in a confidentiality ring, or that is required. But in any event, Judge Toomey in the High Court, he refused the applicant's application to have their client representative in the confidentiality rings. He said there was no particularly specialised feature of the documentation which would require this. So just moving on to the next slide, and the Court of Appeal decision in Kerrigan. Now, just the applicant didn't appeal the refusal of the discovery of the pricing submission, so that wasn't at issue in the Court of Appeal. They were successful in their appeal against the refusal to grant discovery of the notice party's tender relating to combining the services, with the Court of Appeal remarking that there was an interconnection between kind of the pricing and the combining of the services, and that without access to the actual methodologies, the applicant would be at a litigation disadvantage, and that the fair disposal of the proceedings did require discovery of that to be made. Now, it's to be made within the confines of the confidentiality ring, of course. And just moving on to the next slide, the applicant also appealed the refusal of Judge Toomey to allow the client representative access into the confidentiality ring. And the Court of Appeal remarked that no case had been cited where an Irish court had permitted this. And as I said, the parties debated at length Judge Clark's decision in the Supreme Court in word perfect. But the Court of Appeal ultimately held that Judge Clark had not intended to approve English decisions which had allowed client representatives into confidentiality rings. I think that Judge Clark, where he was referring to ways that a tender's confidential information can be protected in a public procurement case. He gave an example of cases in England which were public procurement cases which dealt with confidentiality rings. The Court of Appeal held that he hadn't intended to approve the fact that a client representative, as a matter of course, should be allowed into the confidentiality ring. So just moving on to the next slide, I just came across, I know I said I was only dealing with Irish decisions, but I came across this decision of the English High Court very recently, where they seem to take quite a different view of client representatives in confidentiality rings. And it seems to be the norm. So in Lime Technology, the English High Court noted that the authorities in England emphasise that the inclusion of a client representative in a confidentiality ring is the norm and not the exception in procurement challenges, and needs to occur at an early stage. And that's a reference to a case called SCRL or SRCL maybe. And the English High Court said that once initial disclosure has been given, the challenger must decide whether to commit time and money to the proceedings, and that this needs to be an informed decision. And the assessment and formulation of any pleadings and any amendments of pleadings are not matters which a lawyer can carry out without the benefit of somebody experienced in the commercial activity in which the client has been engaged. But here in Ireland, as everyone here knows, once you get discovery in a public procurement case, somebody usually comes along and the applicant will usually amend their pleadings. And if there's a confidentiality ring, then the lawyers will have to do this without reference to the client, and that can be difficult. So here the English High Court say that that's a very particular reason why there should be a client representative in the ring. And they did remark that in some cases an expert might be a satisfactory solution, but in that particular case, no expert had been identified by the claimant as having been appropriate, and the court accepted that it was the claimant that must make the informed decisions and was entitled to form its own view based on its own knowledge and experience. So there does seem to be a divergence in views between the Irish and English courts about client representatives in confidentiality rings. So it may not be the last we hear about that. So finally, the last case that I want to discuss in the last area is coincidentally abnormally low tenders. And this is the Court of Appeal decision in Killary Lighting Services and Mayo County Council. So obviously there's a High Court and a Court of Appeal decision here, and the actual subject matter of the decision was that Killary's bid had priced 66% of rates at 1 cent, and Mayo County Council had engaged in extensive correspondence over the genuineness of the bid. This concerned a street lighting contract similar to the White Mountain one. And in response to this, Killary had not given very detailed responses. They considered mostly of just assurances or confirmations that they would stand over their bid, or that, we've used this approach in other contracts to date and therefore it's fine. Mayo County Council had excluded Killary from the competition due to their failure to provide this sufficient reassurance regarding their abnormally low pricing. And Killary had argued that the council had vetted its discretion in believing that there was a mandatory obligation to request further information when it considered Killary's bid contained abnormally low pricing. So the High Court decision in Killary was by Mr. Justice O'Moore, and both the decisions in Killary and the decision of Judge Michael Quinn in White Mountain, and just turning to the next slide, please, they confirm the obligations on contracting authorities pursuant to Regulation 69, and the issue of abnormally low tenders hadn't been dealt with in any detail really by the Irish courts, and there are two comprehensive judgments on the obligations now. So what is required under Regulation 69, according to White Mountain, is that there has to be a prima facie assessment of each bid to determine whether there's any evidence to suggest that the bid is suspicious. If it's suspicious, then the authority must investigate, so it must carry out this Regulation 69 inquiry. Now, I've said here on the slide that once they carry out the inquiry, they can reject the tender. But Dorit and Niall drew my attention this morning to a decision from the European Court, which I think only came out the other day, which might seem to suggest that there isn't a discretion if after carrying out the investigation if you find that there's an abnormally low tender, that you are obliged to reject it. Now, in the White Mountain decision, Judge Quinn reviewed the European authorities, in particular a decision called Veridos, and he came to the conclusion that if after carrying out the inquiry that the contracting authority still has a discretion whether to accept it or reject it. That's the conclusion that he came to. The decision from the European Court, I think it's called NTT, so haven't had a chance to examine it in that much detail, but it may be that it's saying something different. So just moving on to the Court of Appeal decision in Killary. The Court of Appeal confirmed the High Court decision that a contracting authority is not obliged, after they carry out this inquiry, to accept a tender's explanation for a price that appears abnormally low. They are entitled to reach their own conclusions. So they were entitled to consider that Killary's explanation regarding, we've done it before in other contracts, did not satisfactorily explain the price or the costs. And the Court of Appeal also confirmed the High Court decision that the council was entitled to assess individual rates and not just the bottom line price. So they could dig down deeper and look at individual rates. And this was consistent with the wording of Regulation 69, which refers to price or costs, which indicates that they're entitled to not just take the bottom line price. And it also confirmed that there is an onus on a tenderer to explain rates that appear abnormally low, and that the council was not obliged to keep going back and seeking further information. Now, that's the abnormally low tender aspect, and the Court of Appeal did agree with the High Court on that. But there is one area of slight divergence between the High Court and the Court of Appeal, and I just deal with that on the next slide. And it concerns the circumstances in which a declaration of ineffectiveness will be granted. So regulation, there was an allegation that the standstill letter wasn't compliant because it had failed to inform Killary of the decision to award the contract to another tenderer and its failure to indicate the exact date on which it was proposed that they would conclude the contract with the successful tenderer. So the requirements for a valid standstill notice are set out in Regulation 6, and that says in part that the notice shall inform the candidates and tenderers concerned of the decisions reached concerning the award of the contract, that they shall state the exact standstill period applicable to the contract, and that's the particular regulation which encompasses the duty to give reasons. So in saying that you have to provide a summary of the reasons for the rejection of the application, and that has to set out the characteristics and relative advantages of the tender selected. So compliance with this provision was regularly challenged in proceedings, and the argument was made that the standstill period hadn't started to run due to failures to comply with the standstill, with Regulation 6 rather. When in the decision in RPS, Judge Humphreys rejected that argument, and he held that the standstill period did even begin to run, even if the standstill notice was lacking in some way. And he said that otherwise there would be intolerable uncertainty regarding when the period had commenced or even expired. Now, the requirements for a compliant standstill letter were considered in the Killary decision. So the Killary were obviously excluded from that competition on the basis that their tender was abnormally low, and on being eliminated, they were told that following the identification of the successful tender and the observance of the mandatory standstill period, it is anticipated that the name of the winner will be published by means of a contract award notice. So it was alleged by the applicant there that the standstill letter was deficient, and that it had failed to provide reasons for the elimination of Killary from the competition. It had failed to identify the specific date on which the standstill period would end, and its failure to state the name of the successful tender. So in the High Court, Judge O'Moore did agree that the letter, the standstill notice, wasn't a valid standstill notice. And he said that while there was no obligation to inform Killary of the name of the successful tender, as they had been excluded, there was an obligation to inform tenders of the decisions reached concerning the award of the contract and the standstill period, because they had been kept in the dark about the date of the award of the contract. And that particular aspect of the decision wasn't appealed to the Court of Appeal. But an issue in the Court of Appeal was this, whether or not a declaration of ineffectiveness should have been granted. And Regulation 9 does provide that the High Court can declare a contract to be ineffective, but the circumstances in which you can do this are confined. Now, it's a fairly strict remedy. It's that any obligations that aren't performed are ultimately cancelled. But the circumstances in which you can get a declaration of ineffectiveness are quite confined, like I said, and they're set out in Regulation 11. And one of the circumstances is where a contract has been concluded during the standstill period, where the infringement has deprived the tender of pre-contractual remedies, and where this has been coupled with a substantive breach of the regulations, and that's in Regulation 11(2)(b). And where these requirements are met, the court only has a limited entitlement not to grant a remedy. So they cannot grant a remedy if overriding reasons relating to the general interest require that the contract should be maintained. So the remedy was considered in Killary, but there are some differences between the High Court and the Court of Appeal. So in Killary, the parties agreed that the failure of the respondent to issue a compliant standstill letter could be treated as a relevant infringement here. So it could be treated as an infringement that the contract had been concluded during the standstill period. And the Judge O'Moore in that case found that he had to consider whether or not that particular infringement had deprived Killary of the opportunity to seek pre-contractual remedies. And he found that it hadn't, that they had actually been informed in unequivocal terms that they were out of the competition, and in light of earlier correspondence, they had not been deprived of the possibility of pursuing pre-contractual remedies, and that one of the conditions therefore in Regulation 11 hadn't been met. And then the court did consider whether or not it could still declare the contract ineffective pursuant to a discretionary power to do so under Regulation 11(7), and that does provide that the court can, after assessing all relevant aspects, declare the contract ineffective. And he said that, well, the first thing that he said was that this hadn't actually been pleaded. And he stressed the importance of pleading to an adequate degree of specificity in public procurement cases. And but despite the fact that it hadn't been pleaded, he went on to consider obiter whether or not they should have been granted a declaration of ineffectiveness on the facts arising. And he held that they couldn't, that the contract was a significant one, street lighting contract, both regionally and nationally. The nature of the works related to public safety and had a public importance. And in those circumstances, a declaration of ineffectiveness shouldn't be granted. Under the regulations, Judge O'Moore did find that the court was nevertheless required under Regulation 13 to grant an alternative remedy. However, he found that because that hadn't been pleaded, he couldn't grant one. So Judge O'Moore was very concerned about adequate pleading in public procurement cases, and that does strike fear into many people, because sometimes these are drafted under intense pressure, and it can be a bit stressful to try and plead everything, and it probably does result in a bit of over pleading sometimes. But Judge O'Moore was quite strict on the fact that he couldn't grant these because they hadn't been pleaded. In the Court of Appeal, then, on the other hand, Judge Hyland takes a slightly different approach. She did hold that Killary had been deprived of the chance to seek pre-contractual remedies because of the deficiencies in the standstill letter. But she did hold that because they hadn't identified any substantial breach of the regulations, then it couldn't obtain a mandatory declaration of ineffectiveness. Going against what Judge O'Moore said, she did find that Killary had pleaded to a sufficient degree a case for a discretionary declaration of ineffectiveness, but she held that in any event, for the reasons already set out by Judge O'Moore, that he was right to refuse the discretionary declaration of ineffectiveness because of the significance of national and local contract and the nature of the works involving public safety and all of that. So the Court of Appeal held...
of time. Can we... Yeah, thanks.
Yeah, this is my last sentence. So just finally, the Court of Appeal found that given the breach of the obligation to provide a standstill letter and the refusal to grant a declaration of ineffectiveness, that there was a mandatory obligation on the court to impose the alternative penalty under Regulation 13, but that was to be paid into the central fund and not to Killary. And Judge Hyland wasn't as concerned about the fact that this hadn't been adequately pleaded as Judge O'Moore. So that concludes my presentation, and I'll hand back over to Dorit, and I'm happy to take any questions later on. Thank you.
Sorry for interrupting there, Aoife. I have a couple of questions, but I hold them because I'm conscious of time. So I will pass straight over to you, Niall, to tell us all about freedom of information requests, which actually we've advised on a few of those ourselves in recent times. So for me, it's a very topical or timely subject. Over to you, Niall.
Thanks very much, Dorit, and hello, everybody. Just to signpost things, what I'm going to discuss over the next 15 or 20 minutes is as follows. First of all, the procurement context in which we're looking at the use of FOI, then where FOI fits in. After that, we're going to look at some basics that are important to bear in mind in relation to what FOI can offer. Following that, then we'll have a look at some kind of inherent limitations on the use of FOI that it's important to bear in mind. And then we'll draw some conclusions on the use and utility of the use of FOI in procurement disputes before we conclude with some practical tips and takeaways. So next slide, please. Okay, what's the context? The context here is where a candidate or tenderer is questioning their failure to qualify to participate in a process, or as the case may be, their failure to be awarded a contract. And as we know, where the process has been run under EU procurement rules, very tight timeframes apply, as Aoife has just mentioned again. And in particular, any court proceedings must be launched within 30 days of any infringement that is identified. So in the case of a tenderer who discovers they've been unsuccessful in a process, they will have received certain information as part of the procurement sort of scheme. In other words, they'll have received a notification that they've been unsuccessful. They'll have received a debrief and some reasons, as well as the relative advantages and characteristics of their bid as against the winning bid. And they'll have been told that a standstill period of 14 days applies usually before the awarded contract will in fact be executed with the winning bidder. As well as that, they will know, as I just said, that in addition to bringing the proceedings within 30 days, if they are minded to do so, they must also first craft a letter, a detailed letter to the contracting authority, setting out the infringements that they perceive attend the procurement decision or process concerned. So that's a lot of work to get done in a short period of time on the basis of what might well be somewhat skeletal information available to the candidate or tenderer concerned. So next slide, please. So where then does FOI fit in? Well, obviously in that context, and as Aoife's presentation has just highlighted, access to the greatest possible amount of information is key. And as you may know, the Freedom of Information Act of 2014 provides for two important rights that are germane to this situation. In the first instance, the Act provides for a right of access to records that are held by a contracting authority, also to records that are not kind of physically held, or physical maybe is an old-fashioned expression, but are not kind of perhaps thought of as being held by the contracting authority, but are nevertheless under its control. And that's a sort of a similar test to the discovery test in terms of records that are within its procurement, power of procurement. And then thirdly, also the FOI Act extends the right of access to records that again are not held by the contracting authority itself, but are held by providers of services to the contracting authority, provided the records relate to the service provided to the authority. And that can be of relevance to procurement process where consultants or advisors have advised the authority in relation to matters concerning the procurement. And you may not have realized this, so maybe a value-added aspect to bear in mind is that even their records may come within the purview of a request that you put in for access to records. So that's the right of access to records. Then you have a separate and standalone right to be provided with a written statement of the reasons for any decision that affect you individually. And also in that statement, you're to be provided with any findings on any material issues of fact made for the purposes of the decision. So there are two rights, separate and independent rights provided for in the FOI Act that are and usually that can be and are often invoked in the case of procurement processes. Also, given that in advance of any possible court proceedings being mounted, there is no other platform for seeking additional information that may help a person to figure out whether any procurement process or decision is unlawful. These facilities to obtain information under the FOI Act assume a very central importance, I would say. So next slide, please. So let's have a look at some important basics then of FOI. As I've already mentioned, the FOI Act confers a right of access to any record held or under the control of any public body or FOI body, which is defined in the Act, or held by any provider of services to the body. Now, most contracting authorities will come within the definition of FOI body and therefore will be susceptible to FOI. The right of access to records is a right to obtain access to records, not information per se. There's a distinction there. So non-recorded information is not accessible under the FOI Act if information is in the heads of persons within the contracting authority but has never been recorded. That's not accessible by means of request under the FOI Act. request of access to records. But having said that, record is a broadly defined concept in the Act, and access can be sought to anything containing recorded information. So apart altogether from the normal kind of paper records or electronically stored information, that would include things like audio or audiovisual recordings, photographs, text messages, post-it notes, anything, literally any medium that contains information. And also the right of access doesn't necessarily or at all mean that you're looking for a copy of a record, be it paper or electronic. You can also seek or be offered inspection of records and various other means of getting access. So access is a broader concept as well than you might think. And as I said as well, the FOI Act confers this additional and standalone right on persons to apply for written statements to be provided to them, setting out the reasons for any decision that's been taken and which individually affects them, and also setting out any findings on any material issues of fact that were made for the purposes of the decision. Now, unlike what I was saying a moment ago, where the right of access provided for under the FOI Act doesn't give you a right to unrecorded information, this would require the FOI body, or in the case of a procurement process, the contracting authority, to supply any reasons, be they recorded or re-recorded or not, that actually subtend any decision that's been taken that affects a candidate or tenderer, and set out the material issues of fact that were found to underpin that decision. And as I say, these rights can be and frequently are exercised in tendering contexts, and in particular upon receipt of a decision letter and debrief information. So given that having the maximum amount of information possible will enhance the chances of questioning any process or decision, these FOI rights can be a powerful complement to the information rights already provided for under the procurement rules. Next slide, please. Now, there are some limitations on the use of FOI, and whilst it has the potential to provide disappointed tenderers with valuable additional information, these limitations particularly center around the following: the timeframes involved, the exemptions, and cost/volume limitations. So as regards timeframes, a request for access to records or for statement of reasons and fact-finding falls to be decided within 4 weeks. That's defined in the FOI Act as 20 working days. So a week is 5 working days. So you're only going to get your information, if you're going to get it at all, within 4 weeks, 20 working days of putting in your request. And in the case of a request for records, this time can even be extended in case of voluminousness by up to another 20 working days. Then, if you get a decision that is negative or partially negative, and you don't agree with it and you think there might be more information that ought to be released, you may seek an internal review within the contracting authority concerned, and that must issue within another 15 working days. So by this stage, it might have taken 20 working days. You've put together an internal review. That's another 15 working days. If there was an extension of time in the first instance, it could have been another week or 2 or 3 or 4. So you can see that the days are mounting up, and the time for using the information to complement your questioning of any process is being eaten up as well. If the tender is still unhappy, they can also seek an external review before the Independent Information Commissioner, and that process can then take a number of months. The Commissioner's decision is then itself subject to an appeal to the High Court on a point of law, which can be taken by any party. And if that happens, the appeal obviously will cause the Commissioner's decision not to be given effect to until the appeal has been decided. And of course, the appeal itself might determine that the Commissioner's decision shouldn't be given effect to at all. So as regards exemptions then, you're obviously not going to get access to any and all information. And as you might expect, the Act provides for very unsurprising exemptions in respect of other people's confidential information, commercially sensitive information, legally privileged information, personal information, and so on. So as Aoife mentioned a moment ago, the court's obviously very alive to the nature of information that might be contained, might be held by contracting authorities, might be sought in the context of disputes, and how confidential and commercially sensitive information is jealously guarded and not easily disclosed, particularly to competing tenderers who are questioning processes. Some exemptions are also subject to a public interest test, whereby the FOI body may decide that admittedly exempt information falls on balance to be released in the public interest. And such decisions, in the case of where they propose to release what is otherwise confidential, commercially sensitive, or personal information, require a consultation process to be undergone with persons who would be affected by release of that information. And that can also involve a delay, particularly where there's then an appeal to the Information Commissioner, where the consultation results in the body still deciding that it wants to release the information to the requester in the public interest, even though it's exempt. Then as regards to the final issue here, and the limitation, cost and volume, the FOI Act does provide that FOI bodies must charge for search, retrieval, and copying of records once the estimated cost equals or exceeds €101 worth of search, retrieval, and copying. Those charges set out in regulations made under the FOI Act, and they provide basically for, they include a charge for €20 an hour for search and retrieval. They also provide that the maximum that can be charged for search, retrieval, and copying is €500. But what they do is they say there's an overall ceiling limit of €700 worth of search and retrieval and copying, and that if the FOI body estimates that the search, retrieval, and copying will exceed that, then they can request the requester to either refine their request to bring it below that, or refuse to entertain the request at all. So they have this discretion to, where there's about 35 hours worth of search, retrieval, and copying involved, to say to a requester, this takes you over the overall ceiling limit. Please refine your request, and if you don't refine your request, we will not deal with your request at all. And this, in fact, happened to me in a procurement process where we were acting for a challenger. We had obtained an order for discovery. That order did not cover certain categories that we had looked for. We sought the same information that we had failed to obtain on discovery by way of FOI. We were told that the upper ceiling limit had been exceeded, that there were tens of thousands of euro worth of search, retrieval, and copying involved, and that if we didn't refine the request, we would be refused. We were unable to refine the request, and it never went ahead. So a salutary lesson there. Next slide, please. So what then are the conclusions we can draw on the utility of the use of FOI in procurement disputes? So leaving aside some of its cousins, like the access to information on the environment regulations, FOI is really the only all-round information access tool available outside of the litigation context. Obviously, litigation, then you'd have the facility for discovery. It has FOI's limitations in terms of whether the request will be entertained at all, as we've just seen, what information might be released or how much, and then when information might come on stream, given the timeframes involved in decision making and the review and appeal mechanisms. However, it is nevertheless worthwhile availing of. First of all, because it's the only show in town, as it were. Secondly, because you never know what you might get, and if you don't try, you certainly won't receive anything. Thirdly, because even if you don't receive information in the very short term, you may do so as matters progress, and the information may still come on stream at a point where it is useful, for example, in the course of any proceedings that are initiated, if that's the case. And finally, penultimately, the fact of making the request itself may have a sobering/leverage effect on the contracting authority, insofar as it'll be aware that certain information may be or may be ordered to be disclosed in the future, even if it isn't now, and that this information might be compromising to its position or to its defense of any proceedings, or at the very least, embarrassing or awkward in the future, or possibly even a basis for proceedings being issued or pleadings being amended if a particular matter comes to light once the information is released in due course. And finally, of course, the FOI Act can also be availed of subsequently to the sort of if you want to call it litigation phase, so that if litigation is actually initiated, it can be used during any proceedings as an adjunct to discovery, for example, to seek to obtain records which weren't within the scope of any discovery that had been ordered. Note that if discovery is made and overlapping records are sought under FOI, the latter records will be refused under the contempt of court exemption in the FOI Act. So if you obtain records under FOI, you can get the same on discovery, albeit maybe you won't because it's not necessary because you already have them. If you obtain them on discovery, and even though they're accessible under FOI, you'll be told there's a rule that says you can't get them that way around because it's deemed to constitute contempt of court because of what you might do, having regard to the unfettered use under FOI compared to the, as it were, fettered and conditioned use under discovery that you undertake to the court on the other side. Next slide, please. So practical tips and takeaways. We'll start with candidates or tenderers. I suppose what I've been saying suggests that you should submit a focused FOI request for access to records related to the decision-making process and the decision affecting it. You should also submit a focused FOI application for a statement of reasons and underlying fact-finding. You should submit these as soon as possible after being notified of any decision. You should also submit a request, or could also submit a request during any proceedings that you might bring as an adjunct to discovery. And bear in mind the upper ceiling limit and my story about a request not having been dealt with at all in a procurement litigation context. Try to keep the request as limited and focused as possible to avoid possible refusal on the ground of voluminousness and overall ceiling cost grounds. Next slide, please. And the final takeaways then for contracting authorities. It may be a good idea to ask tenders, this is often done in your request for tenders, to specify in their tender responses which information is considered by them to be confidential and commercially sensitive, as this will assist you in identifying such information when subsequently applying exemptions in the course of an FOI process. Secondly, consider at the outset whether the request can be refined or limited or even refused under the cost voluminous provisions of the Act, including that overall ceiling limit I mentioned. Thirdly, in the case of reasonably voluminous requests, consider whether you have grounds for extending the time for issuing your first instance FOI decision, which may be extended by another 4 weeks, as I said. Fourthly, consider applying any applicable exemptions, and carefully do so, and consider any public interest overrides that apply. And fifthly, in a discovery or FOI context, if discovery is ordered or agreed, refuse exemption. It's going to hand back.
Okay, thanks very much, Neil. I think, I don't know if it was
for the Q&A.
Sorry, I don't know if it was my side or your side, Neil, but you were breaking up slightly there towards the end. But thank you very much. And obviously, in terms of procurement disputes, the main exemption that authorities tend to apply is that relating to confidential information or commercially sensitive information. And And here it's really important for contracting authorities to ask tenderers to identify, obviously already in their request for tenders, what information is commercially sensitive. And also for tenderers, it's really important when they put together their tender response to identify, which of the information is commercially sensitive, to flag that early on in the process. I've had a look at some questions, and I think we don't have, unfortunately, much time for questions, but there's one question here on FOI which I think might be of interest, and that relates to versions of records. So Niall, you said that records are very broadly defined, but what happens if they're versions of records and they've subsequently So the various versions of records are drafts, and subsequently a final version of the same document has been prepared. So do authorities have to release these versions as well, these previous outdated versions?
Yeah, the FOI Act, I mean, the answer is yes, they do. The FOI Act doesn't distinguish between drafts or versions of records. They're all individual records. They're all things that exist and contain information. So whether it's a draft or a version or a final version, they all come within the definition of what is a record, and provided that the request puts within its scope drafts, versions, any and all drafts, any and all versions, including the final version, well then all of them are potentially subject to release. And often access to draft or earlier versions of evaluation reports or scoring matrices can be particularly illuminating in procurement matters, because they can be quite revealing about the thinking and perhaps whether it chimes with something that you're already thinking might have constituted an infringement.
Okay, that's really interesting, thanks. And keeping on the theme of records, I see another question on abnormally low tenders, which Aoife, I think is for you. What records do you have to keep as an authority when you assess whether the tender is abnormally low?
So this is dealt with, it's summarized in the White Mountain decision. So first of all, you're obliged to carry out your prima facie assessment. And if you ultimately decide that there's no abnormally low tenders, and you don't have to adopt a reasoned decision about that particular point. However, if an unsuccessful tenderer comes along thinking about a challenge and asks you for the reasons as to why you made a decision that a particular tender didn't appear abnormally low, then you are obliged to give reasons for that decision. And that came up in the White Mountain case. And then when you carry out your Regulation 69 inquiry, if you decide to investigate a tender which appears abnormally low, then you have to adopt a reasoned decision as to the outcome of that inquiry. And that ties in with kind of the general obligation as well under Regulation 84 to document decisions taken in relation to the process.
Yeah, and I think generally speaking, I think the courts have made it clear again and again that it's really important for contracting authorities to keep records of the decisions they've taken and the basis on which they've taken those decisions, and to keep those records on file in case of a challenge or an audit or whatever might be the case. So I think that's I can only kind of echo that and underline the need for good records. Unfortunately, we don't have time for many other questions. One thing I just wanted to briefly mention is the case that Aoife was referring to in relation to abnormally low tenders. And apologies, I've just come back from holidays as well, so I haven't had a chance to read that in any detail. But it's a T16124, a case from the 8th of October, and the General Court it suggests in that case that an authority is obliged to reject a tender which appears to be abnormally low. But as I said, I haven't looked at that in any detail yet, so I will perhaps prepare a summary of that, which will be available on our website. So just Thank you for bearing with us if you're still here, and thank you for joining us today for our webinar. We hope that you found it interesting, and obviously if you have any questions that we didn't get to, I will look at them after this webinar, and also you're very welcome to email me with any question, or I'm sure Neil would also be happy to receive any email. And if you would like to receive the slides for today's presentations, then again, please just let us know. And if you could fill in the survey at the end of the webinar, if you need to receive CPD points, you have to fill in the survey. And if you could let us know of any other topics that you would find interesting for us to cover in another webinar. But again, thank you for joining us today, and particular thanks to our speakers, Neil and Aoife, for taking the time to take us through their subject matters. Many thanks.
Thank you.
Thanks.